Imagine you're selling a huge property. Maybe it's been in the family for generations. You finally get the deal sorted. You think everything's covered. And then, wham, you find out there might be this massive unexpected tax bill heading your way.
Oh, yeah. Enough to wipe out your profit, maybe even more. That kind of shock, that anxiety.
It's immense, right? And that exact scenario, that pastoral anxiety, really set the scene for a massive legal fight here in Australia.
It did. We're talking about a case involving a property near Mudgee, New South Wales, Gundowda station. And it wasn't just some local squabble. It went all the way to the High Court.
Became a landmark case. Suttor v. Gundowda Ltd.
Exactly. And it fundamentally changed things. How we look at contract law, definitely, but also, maybe even more importantly, how lawyers actually run cases, how they argue things in court.
So for this deep dive, we've gone through the High Court judgment, looked at legal analysis, tried to piece together the context.
Yeah, our mission here is really to unpack it all. The people involved, and they are quite the characters, the deals that kept changing, the courtroom showdowns, and then figure out how this one sale ended up shaping Australian law so significantly.
It's a real mix, isn't it? Like rural life, high-stakes negotiation, and the sometimes pretty unforgiving letter of the law.
Definitely. Let's get into it.
Okay, so picture this. It's the late 1940s. World War II is over. But Australia's still finding its feet economically.
Yeah, post-war flux. And that meant government controls were still a big thing, especially for large land sales. You needed the treasurer's consent.
Right. You couldn't just sell a massive property like Gundowda Station, was it 45,000 acres?
Around that, yeah. Huge place near Mudgee. Selling that was a major undertaking. And that need for government consent adds this whole layer of uncertainty right from the get-go.
A potential hurdle, which, as we'll see, becomes pretty important later on.
Absolutely. So that's the setting. Now, who are the key players?
Well, center stage is Mr. Suttor. He's the seller, the vendor, likely from a prominent local pastoral family, owned this big station.
And his driving force, almost an obsession it seems from the reports, was tax. Income tax. Specifically, the tax hit he'd take from selling all the livestock along with the land.
Thousands of sheep, presumably.
Exactly. And throughout this whole saga, his main aim seems to have been getting bulletproof protection against that tax bill.
He felt he didn't get it in the end.
That's the crux of it. He felt exposed, possibly misled, and that's why he dug his heels in and fought it all the way. You have to understand that tax anxiety to get his perspective.
Okay, so who was he dealing with?
That would be Mr. McManamy. He was the agent for the buyer, a company called Gundowda Piety Ltd., which was actually being formed at the time. McManamy was the negotiator.
And the court had some choice words about it.
They did. The judgment mentions his conduct, particularly around not passing on information, saying it does not indicate that he is a man of the highest morality. It's pretty pointed language from a judge.
Yeah. Wow. So what information didn't he pass on?
Crucial information about the tax situation. He got it directly from Suttor's own accountant. His job was to secure the deal for his side, Gundowda Piety Ltd., but his actions, or maybe his inaction, became a massive point of dispute.
Which brings us to the accountant, Mr. Walter.
Yep, Mr. Walter, a partner in Langdon and Walter, Suttor's tax accountant. And interestingly, Suttor himself introduced McManamy to Walter. Told him, go check the tax figures with my guy.
So Suttor wanted transparency on the tax.
It seemed so, initially. But Walter, when McManamy met him, didn't mince words. He gave a really stark warning.
What did he say?
He told McManamy that the 2,000-pound figure being kicked around to cover Suttor's potential stock tax was wholly inadequate. Not just slightly off, but wholly inadequate. The court accepted Walter's testimony on this.
So McManamy knew. He was told directly by Suttor's accountant the budget was way too low.
Undeniably. Walter even pointed him to the relevant bit of the Tax Act, apparently. So McManamy was fully informed about the risks Suttor was facing under the proposed terms.
And the buyer, Gundowda Piety Ltd.
The company McManamy was representing, they were in the process of formation. One intended director was another accountant, Mr. Allworth, though he'd passed away by the time it got to the High Court. McManamy tried to suggest Allworth gave him different tax advice, contradicting Walter.
And the company itself, they really wanted the property.
Oh, yeah. They didn't just want compensation if the deal fell through. They wanted the land. That's why they sued for specific performance. They wanted the court to force Suttor to sell.
Okay, so we've got the anxious seller, the negotiator of perhaps questionable ethics, the straight-shooting accountant, and the determined buyer. Quite a setup.
It really is. Now let's look at how the deal itself unfolded, because it wasn't simple. It changed shape.
Right, it wasn't just one contract signed and done.
Not at all. It started with an option back in June 1947. Suttor gave McManamy this option. The terms included cash, taking over mortgages, Suttor getting lifetime residency, and an annuity, £480, tax-free.
Tax-free annuity. And what about the big one, the livestock tax?
Crucially, that June option stated the purchaser agreed to pay and be liable for all income tax on the stock sale. Full indemnity.
So initially, Suttor had exactly what he wanted, complete protection from the tax bill.
Absolutely clear. It shows his starting position. But that option, it expired, it wasn't exercised.
Ah, so back to the drawing board.
Pretty much. Which leads us to the contract signed on September 30, 1947. This was between Suttor and McManamy, again as agent for the company being formed.
And the terms changed.
Significantly.
Good.
Total price, £85,000 cash. Now that was effectively £2,000 more in cash than the option implied. The annuity went up to £600.
Better for Suttor.
Not necessarily, because that £600 annuity was now taxable. And here's the absolute key change. That full tax indemnity. Gone.
Replaced by what?
Replaced by that £2,000 increase in the cash price and the £120 increase in the now taxable annuity. The deal was structured so these amounts were meant to cover Suttor's tax liability.
So the risk shifted entirely back onto Suttor. If the tax was more than roughly £2,000, he wore it.
Precisely. A massive shift in risk compared to the June option.
And the timing around this September 30th contract signing. You said it was dramatic.
Almost unbelievable. Remember, Suttor introduced McManamy to Walter, the accountant. That introduction happened on the morning of September 30th.
The very day they signed this new contract.
The very day.
Yeah.
McManamy then has 2 interviews with Walter. Suttor isn't there. And it's in these meetings that Walter gives the wholly inadequate warning about the £2,000.
Okay, so McManamy gets the warning.
Immediately after the second meeting with Walter, McManamy meets Suttor. They then go straight to Suttor's solicitor's office and sign the contract. The one with the £2,000 tax provision that McManamy now knows is wholly inadequate.
Wow. So the implication is McManamy heard the warning and just kept it to himself.
That was certainly the suspicion, the shadow hanging over the deal. The court didn't find he lied to Suttor about what Walter said, but the timing is incredibly suggestive that he suppressed that crucial negative information just before getting Suttor to sign.
Letting Suttor sign thinking he was covered when McManamy had just been told he wasn't.
It appears that way. Then there's a final agreement, the one actually sued upon, dated October 20th, 1947.
More changes.
Not really on the key points. Price, the £2,000 tax provision, essentially the same as the September 30th contract. The court later basically said, look, if Suttor was induced into the September deal by something dodgy, that likely carried over to this October one.
Okay, so October contract is signed, Suttor gets cold feet, presumably realizing the tax exposure.
Or perhaps getting further advice. Whatever the reason, he refused to complete the sale.
And Gundowda Ltd. wasn't having it. They sued.
Straight to the Equity Division of the NSW Supreme Court, seeking that order for specific performance. Forced the sale.
And Suttor geared up for a fight?
He certainly did. The trial before the chief judge in equity, Roper CJ and EQ, was a marathon. 12 days.
12 days. That's a long trial. Lots of evidence, I imagine.
Huge amounts, and things got really heated mid-trial.
Oh.
On the 7th day, Suttor's legal team dramatically amended his defense.
Adding something new.
Something big. They added an allegation of fraudulent misrepresentation against McManamy.
Whoa. What specifically?
They claimed McManamy hadn't just suppressed Walter's opinion, but had actively lied to Suttor after meeting Walter, claiming Walter had said no income tax would be payable on the sheep.
That's a massive accusation, claiming he fabricated what the accountant said.
It is a very serious allegation and a high-risk move to add it so late in the trial. It significantly raised the stakes.
And who were the lawyers battling this out in the Supreme Court?
We know the teams. For Suttor, the defendant, it was Mr. Shan KC and Mr. Keto KC leading King's Counsel.
And for the plaintiff, Gundowda TIA Ltd?
They were represented by Mr. Snelling. Suttor's solicitor on the ground, handling the paperwork and instructions, was Mr. H.F. White from Mudgee.
Okay, so after 12 days, all this evidence, the fraud allegation, what did Chief Judge Roper decide?
His judgment hit several key points. First, he believed Mr. Walter, the accountant. He accepted Walter's evidence that he did warn McManamy the £2,000 was wholly inadequate.
So point one, McManamy knew the figure was bad.
Established fact, according to the judge. But second, and crucially for Suttor, the judge was not satisfied that McManamy had actually made that alleged fraudulent misrepresentation.
Suttor couldn't prove the lie.
Exactly. The judge found Suttor hadn't met the burden of proof required to establish fraud that McManamy had explicitly claimed. Walters said no tax was payable. Proving fraud is tough.
So the judge saw it maybe more like McManamy just stayed quiet about the warning rather than actively lying.
That seems to be the implication. Suppression, perhaps, rather than outright fabrication. The judge also made an interesting finding about Suttor himself.
What was that?
He found Suttor genuinely seemed to believe that the way the contract was structured, particularly valuing the stock at book value, did protect him from the tax liability. And the judge said this belief wasn't unreasonable, given how complex Section 36 of the Tax Act was.
So Suttor wasn't just being difficult, he might have genuinely misunderstood his position under the complicated tax law.
That's what the judge suggested. The complexity of the law itself played a part in the confusion.
So with the fraud allegation not proven, what was the final outcome in the Supreme Court?
Specific performance was ordered. Roper, CJ, and EQ found the contract valid and enforceable. Despite the questions around McManamy's conduct and Suttor's obvious tax fears, the legal requirements for forcing the sale were met. Suttor was ordered to sell Gundowda.
Tough result for Suttor. Before we jump to the High Court appeal, maybe let's quickly nail down those two background legal issues. The tax and the consent requirement.
Good idea, because they're constantly lurking in the background. The tax first. Section 36 of the Income Tax Assessment Act 1936. That was the source of all the angst.
And the issue was the difference between the stock's book value and its real market value.
Exactly. Sell livestock as part of a property disposal, and that difference could suddenly become taxable income in one hit. Walter's warning highlighted this 1 pound difference per head. 12,000 sheep, potentially 12,000 pounds tax.
Compared to the 2,000 pounds in the contract. Miles apart.
Miles apart. Even if the final figure wasn't that high, the High Court agreed the liability could be considerably in excess of 2,000 pounds. So it was a genuine, significant financial risk for Suttor, a ticking time bomb under the deal.
And the other issue, the post-war regulations.
Right, the need for Treasurer's consent for the sale. This came from the Defense Transitional Provisions Act 1946, carrying over wartime controls. Buying without consent was actually an offense.
And the regulations set standard time limits.
Usually apply within 3 months, get consent within 6, unless the parties agreed otherwise.
But this contract had its own clause, Clause 12.
It did. Clause 12 set a tighter deadline. Consent needed within 2 months, which meant by December 20, 1947, or an agreed extension.
And the crucial bit, what if consent wasn't obtained by then?
The clause said the contract should be deemed to be canceled. And that phrase, deemed to be canceled, became a massive legal argument. Did it mean automatic cancellation? Poof, contract gone. Or something else.
Okay, so Suttor loses in the Supreme Court. He's ordered to sell, but he doesn't give up.
Not a chance. He appeals to the High Court of Australia. Latham Chief Justice Williams and Folligar justices heard it.
And the legal teams, Suttor still had Shan Casey.
Yes, Mr. Shan Casey led for Suttor again. But interestingly, for Gundowda Pity Ltd., the respondent, Mr. Kiddo Casey, appeared.
Wait, Kiddo Casey had been with Shan for Suttor in the Supreme Court.
That's right, a switch of counsel representation between the trial and the appeal for Kiddo, a notable detail.
Okay, so what were Suttor's arguments in this final round?
He led with a bold argument, trying to use the Supreme Court's findings to his advantage. It was framed around sharp practice and hardship.
Sharp practice, even though fraud wasn't proven?
Yes. Shan Casey argued that McManamy's suppression of Walter's warning knowing the 2,000 pounds was inadequate, but letting Suttor sign anyway amounted to sharp practice. Maybe not fraud, but certainly unfair dealing.
And the consequence?
He argued that because specific performance is a discretionary remedy, the court doesn't have to grant it, forcing Suttor to sell under these circumstances, facing a potentially huge unforeseen tax bill due to this sharp practice, would cause inequitable hardship. Therefore, the High Court should exercise its discretion and refuse to order the sale.
That sounds like a plausible, equitable argument. How did the High Court take it?
They didn't take it at all. They refused to even consider the argument on its merit.
Refused? What?
On procedural grounds. Because this specific argument, sharp practice leading to hardship based on the suppression of Walter's opinion, hadn't been properly pleaded or argued at the trial before Roper, CJ, and EQ.
Ah, the rule about raising new points on appeal.
Exactly. And this case is a classic statement of that rule. The High Court cited Precedent, Connecticut Fire Insurance, saying if a point wasn't taken in the court below, and evidence could have been given there that might have prevented the point from succeeding, you cannot raise it on appeal.
So, because Gundowda's lawyers didn't have a chance to specifically address the sharp practice by suppression argument with evidence at trial.
Suttor couldn't ambush them with it on appeal. It's about fairness and ensuring the trial judge gets to consider all the relevant arguments and evidence before making a decision, especially a discretionary one like specific performance. Roper CJ and EQ never had the chance to weigh this specific equitable defense.
So that ruling itself became a major takeaway from the case.
Hugely important. It's constantly cited for the principle that you've got to put your whole case forward at trial. You don't get a second bite at the cherry on appeal with new factual arguments.
Okay, sharp practice argument out. What about Clause 12 and the Treasurer's consent deadline? The deemed to be canceled point.
Suttor argued the contract automatically died on December 20th when consent wasn't there. The High Court rejected this for two independent reasons.
Right, you mentioned two answers earlier.
First, the factual one. They agreed with the trial judge that there had been an oral agreement between Suttor and McManamy to extend the time for getting consent. And since Suttor hadn't pleaded the statute of frauds defense, which requires land contract variations to be in writing, this oral extension was effective.
So, factually, the deadline hadn't strictly passed anyway.
Correct. But the second reason is the major legal principle. They interpreted what should be deemed to be canceled actually means in a contract clause like this.
And this is the void versus voidable point.
Precisely. Following the English case New Zealand Shipping Co., the High Court held that such clauses generally make a contract voidable, not automatically void.
Meaning?
Meaning, the failure of the condition, no consent by the deadline, doesn't automatically kill the contract. Instead, it gives one or possibly both parties the option to terminate it.
An option they have to exercise.
Yes. If one party caused the failure, only the innocent party can choose to end it. If it happened without fault, which they thought likely here for the initial delay, potentially either party could avoid. But crucially, the party wanting out must clearly communicate their decision to avoid the contract.
And Suttor didn't do that in time.
Correct. The Treasurer's consent did arrive on January 5, 1948. Suttor's solicitor didn't send the letter trying to cancel until January 15th. By then, it was too late. The condition had been fulfilled. The right to avoid, if he had one, had evaporated once consent was granted. Plus, there was evidence he'd treated the contract as ongoing in late December.
So that automatic cancellation argument completely failed.
Completely. And established that hugely important precedent about conditional clauses being voidable, not void.
Okay, one last argument. Clause 8, the employment of relatives.
Suttor argued this made the contract one for personal services, which courts won't specifically enforce because they can't supervise ongoing employment.
But the High Court didn't buy it.
No. They agreed with the trial judge. The clause didn't require the court to supervise the employment. It required the purchaser, Gundowda Fide Ltd., to enter into a deed with the relatives, setting out their employment terms.
Ah, so the main contract just required the creation of another legal document.
Exactly. The High Court could order specific performance of the obligation to execute that deed. Once the deed was made, the relatives' rights flowed from that document, which they could enforce themselves if needed. It was seen as ancillary to the main sale and for the employee's benefit, not a reason for Suttor to escape the whole deal.
A practical distinction. So after all that,
all grounds of appeal failed. The High Court dismissed Suttor's appeal with costs.
The Supreme Court order stood. Suttor had to sell Gundowda.
A definitive end to a long and complex legal battle.
So looking back, Suttor v. Gundowda wasn't just about one farm sale gone wrong. It really echoed through Australian law.
Absolutely. Its legacies are significant and still relevant today.
We've touched on them, but let's summarize. First, that voidable versus void interpretation of conditional clauses.
Foundational. That ruling that shall be void or shall be canceled usually means the contract is voidable. Giving a party an option is critical for contract certainty. It stops people using technicalities, sometimes their own failures, to automatically escape deals. Hugely important precedent.
And second, the big procedural one.
The rule on raising new points on appeal. Suttor is the classic authority for why you can't introduce arguments on appeal that needed factual investigation at trial but weren't raised there. It underpins the whole structure of trials and appeals fairness, finality, respecting the trial judge's role.
Forces lawyers to get it right the first time.
It certainly focuses the mind on trial preparation.
What else? Specific performance.
It reaffirmed that specific performance is discretionary, but that discretion isn't arbitrary. Arguments like hardship or sharp practice can be relevant, but they absolutely must be properly pleaded and proven with evidence at the trial level. Suttor's case showed you can't hold them back as an appeal strategy.
And finally, that point about the employment deed.
Yeah, it demonstrated a practical way courts can handle complex contracts that include promises to create future documents or secure rights for third parties. Order the making of the deed or agreement, letting the main transaction proceed without getting bogged down, supervising the underlying relationship. Useful for complex commercial deals.
So it's quite a journey from that initial anxiety over livestock tax.
Through shifting deals, alleged sharp practice, a 12-day trial with dramatic twists.
All the way to a high court judgment that sets down fundamental rules still used every day.
It really shows how these big legal principles often come directly from very human stories. People's worries, their ambitions, the gray areas in negotiations.
The lessons seem pretty clear, don't they? Clear communication, understanding exactly what your contract says, especially the tricky bits like tax and conditions.
And the absolute necessity of getting your arguments and evidence lined up properly at trial. Because, as Suttor found out, you probably won't get a second chance on appeal.
It's definitely a case that stands the test of time in Australian law.
No doubt about it, a bedrock case.
Makes you think, doesn't it? How much really hangs on timing, on what's said or maybe not said in negotiations, and how the law tries to balance enforcing agreements with ensuring some level of fairness, even when one side feels pretty hard done by. What really stands out to you from this deep dive?